Okay, as I was previously saying, the reason I do lean more towards recklessness or rather than negligence in this case is because I think that regardless of what you thought the outcome would have been from a really hot area, it would have been something negative. And I think although you might not have expected it to be death or something as extreme, there is not anything positive necessarily that would come out of a really hot room, which after investigation was shown to be the hottest around the area. So I think from a legal standpoint, it would make more sense to define it as recklessness rather than negligence, again, simply because, like I said, hot room, super hot room, and I'm talking over 100 degrees Fahrenheit, like, could not have possibly been a good thing. Which is why I think, even though maybe the babysitter didn't think it would be that extreme, it's still not an excuse, saying that the parents didn't want her out or any of these things. It's not really, I don't know, valid enough, I guess, in my opinion. But I understand why people would think it is negligence. Like I said, this did take me a while to kind of form an opinion on, just because I do understand where people would be coming from if they thought it was merely negligent, just because maybe she didn't intend to actually cause harm to the child, which I don't know if I think she necessarily meant it, but I do think, like I said, she definitely knew that it was not going to be a good thing. The final decision in the case of the People versus Baker was that Baker was guilty of involuntary manslaughter. Now, do I agree with this standpoint? I think the decision was correct, as the court found that Baker's conduct was not only negligent, but also showed a conscious disregard for her child's safety, amounting to criminal recklessness, basically. Some people might argue that the decision was too hard or too lenient, which fully understandable, but I do think that it was not harsh at all, because this also ties into later on what I think should or should not be criminally punished. Not intention based, but more outcome based, because I just don't feel as if it's fair to punish someone only based on intention, which I'm gonna get more into with the Nevada law of the misdemeanor offense. Then I have okay, should it be punished criminally? So personally, I think yes, it should be punished criminally, because like I said, regardless of the intent, which I think in this case would not have even been dismissed, or as dismissed as, like I said, the Nevada law of the misdemeanor. I feel like, mistake or not, it was reckless at the end of the day, and I think the person is guilty of being reckless, knowing that there could be a negative outcome. Like I said, it couldn't have been as far or as extreme as death, but it was there, and the person knew that. In the end of the day, moving that aside for a second, I think the child, in the end of the day, was harmed. The child was harmed, and there is no arguing that is due to the reckless behavior of the babysitter. So to me, that's just a plus on top of the fact that the child was already harmed. So I think that alone as a factor should have been enough for punishment. Intentional or not, I think in the end of the day, a life was harmed. So would it really be fair to say, this person didn't mean to do it and they shouldn't be punished? I don't really believe so, because I just don't think it does that person justice whatsoever. That is my personal opinion, of course, and that, again, I understand why other people would think otherwise, but I think it is deserving of punishment. What I have written here is whether or not she should be punished criminally is a matter of a legal and ethical debate. Some might argue that she did not intend to cause harm to the child and that her actions were the result of a mistake or an accident. In their view, she should not be punished criminally. Others might argue that Baker's behavior was reckless and that she should be held responsible for the consequences of her actions. They might believe that punishing her would send a message to others to exercise greater care in similar situations. Ultimately, the decision about whether to punish Baker criminally is a matter for the court to decide, based on the facts of the case and the applicable legal standards. Yeah, that's really all I can say about that case. All right, third question I have is in Nevada, it is a misdemeanor offense, vehicular manslaughter, to cause the death of another while driving a vehicle through an act or omission constituting simple negligence, the lowest level of culpability only, like opening a glove box and taking your eyes off the road for a moment, not drunk driving, which is far more than simple negligence. I think this is a very interesting one because I think it really is a summary to all these cases that I'm about to talk about, just because it's simply, well, hey, I didn't know that this was going to happen. I'm so sorry. But it happened regardless. And it isn't as extreme as somebody being drunk and knowing the dangers of being drunk. Because they were just looking at the glove box, right? Hypothetically. Now, from a legal and ethical perspective, the question of whether a misdemeanor offense for vehicular manslaughter based on simple negligence is appropriate or not depending on various factors, such as the gravity of the harm caused, the intent of the perpetrator, the level of negligence involved, and the broader public policy goals of the law. Now, I like to take into account what both parties would think. People who argue that the misdemeanor offense is a reasonable and proportionate response compared to the people that think it's either lenient or harsh. Because it is important to be open, but I do personally think that, like I said previously, if it does cause harm, even regardless of the fact that you were just looking at your glove box, you knew that there was that very, very, very slight chance of the harm being caused. So it's like, I think that's more obviously, well, actually, I think it is recklessness. I think it is more recklessness than it is negligence, again, because you knew that taking your eyes off the road for a little bit, even to, do the most mundane thing ever, could have caused harm. Now, I think the reason that people do these things is obviously because day to day, when you are looking at your glove box, you're not hitting somebody, you're not swerving into a different lane, you're not causing any harm. And obviously it becomes norm to think, well, I'm just going to quickly look. But I think in the end of the day, everybody knows, like, your eyes are supposed to be on the road, you know what I mean? And it is something that is so far in the back of your head because, like I said, it's kind of just like looking at your phone for a second or looking out the window to look at something. It's things that we do, on the daily. And I don't think people realize the risks of it, which I do think should impact the extent of the charge or, I do think it should impact it a little bit. I don't think a person who took their eyes off the road should be charged as much as someone who willingly drank and drove, for example. But I do think it should still be punished if caused harm, because harm was caused, simply because of that factor. Now, I understand that intention plays a part too with this case, but I think it's just, you knew in the end of the day that there is that very, very, very slight chance that something could go wrong. And although you didn't maybe consciously think of it, it's common sense, you're on the road, right? Now I have the question of whether criminal law should punish purely negligent behavior is a complex and controversial one. I think I'm really struggling to understand why this is considered purely negligent. I understand that. Well, I guess I get it. I do get it. I take back what I said about recklessness. I guess they did know, but it also is not expected. I don't know. I feel like it falls kind of in between for me, but either way. On the one hand, some might argue that negligence can be just as harmful and deserving of punishment as intentional or reckless conduct. They might point out that even though the harm caused was not intended, the harm still occurred and should be taken seriously, which is what I said. On the other hand, others might argue that criminal law should only punish conduct that is intentional or reckless, and that negligence should be dealt with through civil liability or other non-criminal means. I personally disagree with the second, just because, like I said, if harm was caused, I think that should be charged by criminal means. I think it really just is my opinion on, if harm was caused or if a life was lost, then that should be paid for in a way. And I don't think it should be as extreme as, like I said, drinking and driving on purpose or literally hitting somebody on purpose, but I still do think, you know, to a certain extent, it's just, it was caused because you were being negligent, and like, it's just not the smartest to be looking at those things while driving when you had the option to stop and do so. You know what I mean? Now, like I said, it shouldn't be as extreme as somebody who did it on purpose, but I do think it should be, one, not only a lesson to teach other people, but also just a way of paying respect to the harmed. I also do think it, you know, depends on how harmed they were and like what actually happened, and all those things obviously play a factor into it too. But I think just the general stance is it should be punished criminally. This is interesting because it's actually making me think about my answer as I go, but I think I'm going to stick with it. What else I have here? They might point out that criminal law should be reserved for the most serious and blameworthy conduct, and that imposing criminal sanctions for purely negligent behavior could lead to overcriminalization and injustice. Ultimately, the answer to this question depends on the specific circumstances, like I said, of each case.